Okay, good evening. Thank you. We have a few folks coming on in. Come on in. We're about to get started. I am Antonio Ugas Jr., Director of the Center for the Study of Democracy here at St. Mary's College of Maryland, the National Public Honors College. I'd like to begin our program by offering an example of how the college is working toward acknowledging our history. We acknowledge that the land on which we are learning, working, and gathering today is the ancestral home of the Kakomoko and Piscataway peoples. We also acknowledge that St. Mary's City was partly built and sustained by enslaved people of African descent. Through this acknowledgement, we recognize these communities and all those who have been displaced and enslaved through colonization. It is an honor to welcome you to our special event this evening. And so good to be in person with so many of you, friends and supporters of the college and of the Center for the Study of Democracy. The Center, as many of you know, is a joint partnership of historic St. Mary's City and St. Mary's College of Maryland. And we are proud to host the annual Judge William O.E. Sterling Constitution Day Lecture. Dr. Jordan, St. Mary's College President, has declared the theme of this academic year to be Keep Up the Momentum, as we continue to rebound from the pandemic and emerge stronger than we were before. And at the Center, we are endeavoring to contribute to this effort by offering programs that inform our civic discourse and encourage participation in our democracy, both of which I believe and I teach are critical in our current political environment. And this effort is also reflective of the Center's mission, which is to explore contemporary and historical issues associated with democracy, liberty, and justice, here at home and abroad. And we do this by pursuing activities that facilitate and strengthen democracy and the rule of law, encourage and enhance civil society and individual freedoms, increase economic, environmental, educational, and cultural equity, all of which coincides with what St. Mary's College, as a premier liberal arts school, is seeking to do as well. In this light, I'm honored to introduce tonight's speaker, Mr. Neal Katyal. Neal Katyal is a former acting Solicitor General of the United States and Paul Saunders Professor of National Security Law at Georgetown University, where he focuses on constitutional law, criminal law, and intellectual property, among other things. Mr. Katyal has argued more Supreme Court cases in U.S. history than any minority attorney, including Thurgood Marshall. In this capacity, he's argued major Supreme Court cases involving a variety of issues, from voting rights to the war on terror in Guantanamo Bay, as well as President Trump's travel ban, to name a few. All in all, Mr. Katyal has orally argued over 40 cases, and as we were talking, I was trying to keep track because he kept naming additional cases that he had argued or was going to argue, but over 40 cases before the Supreme Court, with more to follow in the coming term. Among his many accolades, he was named Litigator of the Year by American Lawyer magazine and is a recipient of the highest civilian award in the U.S. Department of Justice, the Edmund Randolph Award, which recognizes outstanding contribution to the Department of Justice mission. Now, you may have seen Mr. Katyal on TV or, like I do, on social media because he's appeared on many platforms. Every major American nightly news program where he provides commentary and analysis on a variety of constitutional and legal matters. Tonight, Mr. Katyal will speak on the Supreme Court, the rule of law, and the future of American democracy, a topic which couldn't be more relevant. So without further ado, please join me in welcoming Mr. Neal Katyal to St. Mary's College of Maryland.
Thank you all. It's so good to be with you, and it's really just exciting to be back in person. And what a beautiful setting to be in. You all are so lucky to be studying here or working here or living here. I'm trying to go, I've been a Maryland resident for over 2 decades, and so I'm trying to go and speak at every higher education institution in Maryland. I have to say, there's not going to be one that has been or will be more beautiful than this over here. So thank you for having me. So today I want to talk about the Supreme Court, and I know that there's faculty here, there are community residents, and there are obviously students as well. So I'm going to start with some more general stuff and then kind of drill down into a couple of specific stories to just try and illustrate the Supreme Court at its best and maybe the Supreme Court at its not best. So let me start by just telling you a couple of things about the Supreme Court and our 9 justices. Maybe the first thing to say is there don't have to be 9 justices under our Constitution. Article 3 of our Constitution just establishes the Supreme Court, but it doesn't actually tell us how many justices there will be. So that's actually fixed by statute, by congressional law. And we started with 6. We had 5 for a while. 6, by the way, is very weird, an even number, because then they could disagree and be deadlocked. And I've even had that happen to me, where we've been a 4-4 deadlock sometimes. But normally, there have been 9 justices. There have been 9 justices since 1867. At one point, we had 10. But for a long time, since the end of the Civil War, it's been 9 justices, unless there's a recusal or a death or something like that, in which case you could have fewer. And you know, the justices, it's no surprise, they tend to think a lot about themselves, and that's true historically. So, you know, Justice Chase, who was an early justice back in the early 1800s, this is what his best friend said. Quote, "Chase is a good man, but his theology is unsound. He thinks there's a 4th person in the Trinity." Chief Justice Warren Burger, who was the Chief Justice in the 70s and 80s, was rather insecure about his abilities and about his appearances, and so he literally put a cushion on his chair at the court, and so when reporters or the public or advocates would look at him, he'd look taller than the other justices. Then there are other justices who are incredibly humble despite the position they've attained in the world. I can tell you with 100% certainty, I put Ketanji Jackson in that category. And I've known her for even longer than I've lived in Maryland, more than 2 decades. She's now sworn in. She's going to take the bench on October 3rd, and I will be arguing on that day. I'll be arguing my 46th case at the court on that morning, and I'm excited for it to be there for witness to her very first day on the Supreme Court. But as I say, some of the justices do have humility. So, you know, one of my favorite justices was actually William Rehnquist, appointed by Nixon actually as Associate Justice Supreme Court, and then elevated by President Reagan to the Supreme Court, to the Chief Justice of the Supreme Court. Now, there's only one time if you're a sitting justice that you get to give a press conference, and that is if you're elevated to be from regular justice to Chief Justice. And that happened to then Justice Rehnquist back in 1986. So he's giving a press conference, talking about how excited he is. First question from the press gallery: "What did Mrs. Rehnquist say when you called to tell her the news?" Answer: "She said, 'Come back home and unload the dishwasher.'" Even better than that was David Souter, who was one of President Bush's nominees. Now, he was a kind of odd fellow. He really hated Washington, D.C. He didn't like would never go to parties or anything like that. He'd come into court, do his job, go home, not a very social person. He'd have lunch by himself every day where he would literally eat an apple, core, seeds, the whole thing. That's what he ate every day for lunch. And as I say, he hated Washington. And one of the interesting things about the Supreme Court is that they're not on in the summer. So basically June 30th, the term ends. And then it starts again on October 1st or so. So for those months, the justices usually go gallivanting in Europe and stuff like that. It's a great job. It's like, it's like school children. You get the summers off. But Justice Souter really just always liked to go to his cabin in New Hampshire, and he would read Shakespeare and Proust and stuff like that by himself for 3 months. And so term ends on June 30th one year, and he's driving up to New Hampshire from D.C., that about 10-hour drive. He stops in a rest stop in Massachusetts, and there's a couple, a man and a woman, and they see him, and they stop him as he's walking out of this rest stop. And the man says, "I know you." And the justice, who's very polite, says, "I don't believe we've met, sir." You're that fellow on the Supreme Court." And the justice says, "Yes, I am." You're that fellow Breyer, Stephen Breyer." The justice, who's so polite and doesn't want to embarrass this guy in front of his wife, says, changes the topic, and they just, dodges past that, and they talk for a few minutes. And then the justice says, "Well, I'm sorry it's late, but I need to make it to my cabin by nightfall." And so they part ways. And then the man turns around and he says, "Oh, wait a minute, one last question. What's the best thing about being on the Supreme Court?" The justice, without missing a beat, says, "I'd have to say the greatest privilege about being on the Supreme Court is the privilege of serving with David H. Souter." So the path of Supreme Court oral arguments is, there's a legal brief that's filed, or sometimes two. There's sometimes friend of the court briefs, amici briefs from public interest organizations or corporate organizations or whatever that come through. And then there is an oral argument at the Supreme Court, which is kind of like the apex of kind of the whole thing. And it used to be that oral argument was many, many days long. Like Daniel Webster in the old days used to argue some cases for 9, 10 days at the Supreme Court. Now it is a half hour per side. So this was like, I had a Hindu wedding, but I married someone who was Jewish, and so she did not want to have the traditional 8-day Hindu wedding for understandable reasons, so she gave me 30 minutes. Same thing. So we've gone from 9-day oral arguments to 30-minute Supreme Court arguments on each side. So in a 30-minute oral argument, I average about 50.8 questions. So that's more than a question a minute. It's rapid fire. And the justices are really trying to test the logic of your position. So it's not like arguing in lower courts, in which the question is much more, what is the law? What has the Supreme Court said the law is? But rather, what should the law be? And so they're not bound by stare decisis, particularly not these days, as we can talk about in the question and answer session. But so they're really trying to test and understand, if I take this fact out of your case, does the result change? How do we write an opinion that governs not just your case, but the rules going forward for the entire country? And it's a pretty intense thing, I will tell you. I mean, I remember before my first argument, which I will talk about in a little detail, Guantanamo, the clerk of the court, who really did not want me to win this case, he was an Air Force guy, and I had the Navy on my side, but not the Air Force. He put his arm around me. I'd been going to the court for days to watch oral argument and try and get myself ready. And he put his arm around me and he said, "Neal, you look a little scared." And I said, "Thanks." And he said, "Well, don't worry. Only 3 people have died with their boots on." And I said, "What?" And he said, "Yeah, 3 people have died at the podium of heart attacks." I said, "Thanks. That's what you tell a first-time advocate?" It turns out it was right, that 3 people had died at the podium, including, oddly, a man who died of a heart attack around 1900, and then his son about 40 years later at the same podium. It is if you haven't been to the U.S. Supreme Court, it is now going to be back open to the public for argument, so you can watch, and I really would encourage you to do it. The questions are really hard, they're rapid fire, it's an incredibly intimate setting. You're basically about 8 feet away from the Chief Justice when you're arguing, and then the other justices spread out. And so if you're trying to give a speech and you're trying to talk at a distance, you're going to not connect with them. So it's got to be like a conversation. It's got to be almost like I sit there and think I'm like sitting around a dinner table with the justices trying to explain my position. And if I can understand it as a conversation, I think it's going to be better. Now, there's a lot of, obviously, talk about the Supreme Court, a politicized Supreme Court, a predictable Supreme Court. And certainly, I think there's some weight to some of those concerns, and we can talk about that. But I will tell you, sometimes the justices really do surprise you. And you think something is going to be decided a certain way, where the public does, and there's a narrative, and it doesn't get decided that way. My favorite one of those is a case I had called FCC versus AT&T. So this was the year after Citizens United. Now, Citizens United was the enormously controversial case. I was Elena Kagan's deputy on that case when she was Solicitor General. So she argued the case that basically said corporations don't have free speech rights under our First Amendment. They can't just give unlimited corporate contributions. But the Supreme Court, in a 5-4 decision, disagreed and said corporations are people. They have rights under the First Amendment. Therefore, this campaign finance stuff is illegal. So the next year was this case, FCC versus AT&T, which all the New York Times and everyone billed as Citizens United Part 2. And the question in the case was whether corporations have privacy rights. So we have a law, the Freedom of Information Act. And the Freedom of Information Act has an exception for personal privacy. And what the lawyers for AT&T did was they stood up at the Supreme Court after writing their briefs, which said the same thing. They stood at the Supreme Court and said, there's an exception in the law for personal privacy. Corporations are persons. If you look at the Dictionary Act, which is the very first statute in the United States Code, 1 United States Code, Section 1, Chapter 1, Section 1, and you look up persons, it says artificial persons, meaning corporations. So there's an exception for personal privacy in the law. Corporations are persons, ergo, corporations have privacy rights and are exempt from the Freedom of Information Act. That's their argument. Sounded very good. Chief Justice Roberts stops him right there, the lawyer for AT&T, within a minute of the argument, and says, well, there seems to be a problem here because you're saying that corporations are persons, but you're giving it, the law doesn't say persons have an exception, it's personal privacy. And don't words have different meanings sometimes from their roots? And the lawyer for AT&T says, I don't know what you mean. And the chief says, well, the word is personal in the statute. You're just telling me corporations are persons. I don't know if that means they're personal. And the lawyer for AT&T says, I still don't know what you mean. So the Chief Justice gives him some examples. He says, well, lawyer, what about squirrel and squirrely? What about pastoral? What about craft and crafty? The poor lawyer for AT&T has no answer to this. And so this case that was predicted to be Citizens United Part 2, 5-4 decision, unanimous decision rejecting AT&T's argument. The Chief Justice writes the written opinion for the court. The very last lines of the Chief Justice's opinion say, I kid you not, quote, we trust AT&T will not take it personally. All right. Let me give you a little data about the Supreme Court from the last term. They issued 66 opinions after hearing a total of 63 oral arguments. They do hear cases from state Supreme Courts as well as from United States Courts of Appeals, which are divided regionally. The Ninth Circuit, which governs the west of the country, is the circuit that every year has the most cases. Last year, they had 18% of the docket. The year before, it was 23%. So it's an outsized number. 60 cases in a year is very low, or 63 cases is incredibly low. Historically, they often heard 150 cases or something like that, but I will tell you for the last 15 or 20 years since I've been practicing, it's been about 60 to 70 cases a term. So not that many, but each case gets enormous amounts of attention and is obviously very difficult. Now, one other interesting thing is the court's reversal rate. So if the court agrees to hear a case, and they don't have to hear almost anything, it's discretionary. They get about 10,000 requests to hear cases a year, but they only hear, as I say, about 60, so very hard odds. But if they do agree to hear a case, statistically under the Roberts Court, it means they're likely to reverse the Court of Appeals or the state Supreme Court decision that they're reviewing. Last year, they reversed it 82% of the time. What that means in practical terms is if you've won your case in the Court of Appeals and the U.S. Supreme Court agrees to hear it, that's very, very bad news for you. Like last year, you'd have lost 82% of the time. Now, one other thing that I think is helpful to watch is voting alignments. Who's agreeing with who and who's disagreeing with who. So last year, and this has been true, it was also true the year before, if you ask who are the two justices that agree the most with each other, Chief Justice Roberts and Justice Kavanaugh agreed in full 86% of the time last year, in part 97% of the time, and in the judgment, in the bottom line, 100% of the time. So that is the most stable pairing of justices. Justices Kagan and Breyer last year were a shade under that, in full agreeing at 79%, in part 87% of the time. And Justices Kagan and Sotomayor also very similar to that, very similar set of stable pairings. Now, if you ask who's disagreeing the most with each other, that's a little bit predictable. This has been the same answer for many, many years. It's Justices Sotomayor and Thomas agreeing in full last year only 30% of the time, and in part 35% of the time. Justice Sotomayor and Alito, just a shade under that, and Justice Breyer and Thomas is also just a shade under that. And one other interesting thing about this is the rate of unanimity. So Chief Justice Roberts came in his confirmation hearings, he said he really wanted the court to try and speak with one voice. And he was largely successful until last year. So if you looked to the term 4 years ago, the court agreed in 66% of the cases unanimously. You'd have to go back to the year 1940 to find a similar rate of agreement. That has not been happening, that did not happen last year at all. 29% of cases decided unanimously. And major, major hot button cases, as I think all of you know from reading the newspapers, cases like the Dobbs abortion case, like the New York rifle gun control case, like West Virginia versus EPA, the climate case, decided on 5-4 or 6-3 grounds, and really, really bitter dissents, which are disagreements, written opinions that disagree with the majority of the court. So we can talk about some of those in the question and answer, but that is also stuff that saturates the news. And what I thought I'd like to do, and I thought it'd be a little more helpful to you, is to actually just give you an insider's view of the court and what arguing there is like, but with a lens to trying to understand the role of the court in our study of our democracy. Because the first case I want to talk to you about is the Supreme Court, in my view, at its best, and that is the Guantanamo case. It doesn't have to do with me arguing it. It has to do with the case itself and what happened. So here's the story. The nation is horrifically attacked on September 11th, and I was teaching that year at Yale, and I didn't really know what to do. I wanted to do something, and so I started working with first responders, and I wasn't particularly good at that, but I did what I could. And then, all of a sudden, I found something that I felt like I had some expertise in. I was watching TV, and the CNN had that ticker at the bottom, it still has it now, with the news on it, and it said, President issues trial order for suspected terrorists at Guantanamo Bay. And I thought to myself, that's interesting. How could he set up a military trial system at Guantanamo? I was National Security Advisor at the Justice Department in the prior administration. We had the bombings by bin Laden at the embassies in Africa, and we looked at military tribunals, and we concluded they were obviously unconstitutional. So I thought to myself, I wonder how he's doing it. So I got on my, at that point, dial-up modem, typed in whitehouse.gov into the search bar. This is like before Google. I know this is scary for some of you. And I see this order from the president, and honestly, the first thought I had was, I must have mistyped. This has got to be a joke. I've got to be on like the Onion website or something like that. Because the president was saying, I could set up these military trial systems from scratch. I can handpick the prosecutors, handpick the defense attorneys, handpick the defendants that will go before this, write all of the rules for the criminal trials, define all of the offenses, define what rights they had, which he later said 0 constitutional rights, define the punishments, including the death penalty being on the table, and handpick the judges, handpick the appeals judges, and the very last lines of the order said, federal courts have no business reviewing what I'm doing at Guantanamo Bay, no writ of habeas corpus. Now, I'm a big believer in presidential power, but I thought that was just ludicrous. So I wound up testifying in the Senate 2 weeks later in November of 2001 and said, look, I don't know if we need these military tribunals or not, but the one thing I'm sure of is that the president can't do it on his own. It requires you, the Congress, under our separation of powers. And I talked about how it violated the Geneva Conventions and the like. And the administration sent up a witness, Michael Chertoff, who's become a good friend, and Michael testified and said, look, what if we get bin Laden tomorrow? We need to have these trials. We don't have time to get the separation of powers underway and for Congress to debate this. We need these now. I thought that was a weird argument because we'd passed 15 different laws since 9/11 dealing with 9/11, including the Patriot Act. So it wasn't like Congress was incapable of acting the way like they are now. Back then, they actually did stuff. And so I thought it was strange, but nonetheless, that's what the administration said. Nothing happened. So, we thought the trials would start right away. So I called a friend of mine, Larry Tribe, who's a very famous law professor at Harvard, and I said, we got to write a law review article that tells the world these are unconstitutional, and we race it into print. I don't think anyone read it. My mom might have read it, but I don't think anyone really read it. But no trials happened. No prosecutor was even picked for a year and a half to begin looking at cases. Finally, like a year and a half go by, they pick a prosecutor and they pick a defense attorney. And so I reach out to the defense attorney and I say, I think this is obviously wrong, obviously unconstitutional, and we should bring a test case. And so we start to think about bringing a test case, and I start working with his junior Navy JAG attorneys to orchestrate what that case would look like. And one of the things I believed about the Supreme Court back then, it's a little different now, but back then Justice O'Connor was on the court, and she really cared about the facts of individual cases. Remember, I told you before, most of the time the court's not thinking as much about your case as writing a set of rules for the entire country or world or something like that, and so they're not as concerned about any pesky facts in your case. Justice O'Connor was very much the opposite. Like, if I was going to bring to the court a case from Guantanamo involving someone with serious blood on their hands, it was going to be hard to win her vote. And so I'd given that direction to the military attorneys. So one of the military attorneys calls me and he says, I've got good news and bad news. All right, what's the good news? I've got a guy at Guantanamo who doesn't have blood on his hands. I said, what's the bad news? He's a driver. I said, that's not so bad, he's a driver. Well, he's a driver to Osama bin Laden. And I thought about it for a little bit, and I said, I think we can win that case. I think that's fine. And so we brought the case, which represented a guy named Salim Hamdan, who is accused of being Osama bin Laden's driver. And we argued that it violated the separation of powers and the Geneva Conventions, and that the president couldn't do this on his own. And we won that challenge in the trial court, in the district court. We then lost it in the circuit court on July 12, 2005, in the D.C. Circuit, our nation's second highest court. On that court and on that decision was a guy named John Roberts. That was July 12th. On July 15th, John Roberts is nominated to become Associate Justice of the Supreme Court. And 2 weeks later, he's nominated because of the unfortunate death of William Rehnquist, nominated then to become Chief Justice of the Supreme Court. So my task is to get the U.S. Supreme Court to hear this case and reverse their new Chief Justice's most important opinion he's ever written. And by the way, the opinion was about 20 pages long against us. There were 6 issues in the case, and we lost each of them 3 different ways. So 18 different holdings against us, all in the span of about 20 pages. So they were really, sticking it to us. But nonetheless, we go into overdrive, and we get the Supreme Court to agree to hear the case in November, on November 7th. 3 days later, the Senate passes a bill to remove the case from the docket of the Supreme Court for the first time since the Civil War. I kid you not, Lindsey Graham goes to the floor of the Senate and says basically, the terrorists are overtaking our Supreme Court. We got to divest them of jurisdiction. So that was obviously also a constitutional problem. So this case, which I was already freaked out about arguing, it was my first, now becomes an even bigger case about can Congress try and divest the Supreme Court of jurisdiction in an ongoing case. And I did what I thought the right thing was. I thought, I should try and give the argument away to someone who knew what they were doing. I had clerked on the Supreme Court, but it wasn't something I had done before, and I wanted to have an experienced advocate. So I called my friend, who sadly just passed away, Ken Starr, and I asked him, who was Bush's Solicitor General, and I said, would you argue this case? And he said, absolutely, I'd be honored. But his law firm wouldn't let him. I mean, representing bin Laden's driver is not exactly, great for business. And then I called another friend of mine, a great advocate, who couldn't do it. And so ultimately, I wound up doing it. And so I'm arguing my first case against President Bush's, this George W. Bush's Solicitor General, his 35th case. And I was completely freaked out. And I remember what I did was I just said, look, if I'm going to do this, I'm going to try and do it in a way in which I understand everything about the case, mooted it, practiced it every which way. So I took a legal pad out, and I wrote down the names of all the people who intimidated me the most in the country. I mean, lawyers, not like scary people. And I called them all up and I said, will you moot me? Can I practice my argument? And so I went around the country and practiced it. In my very first practice session, I went to Harvard, and Larry Tribe, that professor, was there. And he said to me at the end, he said, you look a little small at the podium. And I said, what do you mean? He said, you don't have presence. You seem too deferential. And I thought that was right. And my military co-counsel said to me, I've got the guy for you. And it's this acting coach, actually. And I'm sitting there thinking, an acting coach? This guy doesn't know anything about the Supreme Court. Terrible, terrible thing. I'm going to waste my time. So this acting coach comes into my office one day at Georgetown. He's got like a billowy white shirt, a bolo tie, and I'm like, this is going to go nowhere. And he looks at me and he's like, I can read your body language. I know you think this is basically a joke, but why don't you just try it, since I flew all the way from, I think, Arizona. I'm like, sure. So he's like, tell me your argument. So I grab my legal pad and I start telling him my argument. He's like, what are you doing? And I said, well, you asked me for my argument. And he said, your argument's a legal pad? And I said, no, my argument's on a legal pad. And he said, tell me your argument. Look at me. So I look at him and I start telling him my argument, not looking at my legal pad. And I instantly relax. And he sees me starting to smile, because what I'm realizing for the first time is oral argument, particularly at the Supreme Court, but truly anywhere, is a conversation. And it's about interaction between human beings. And if you're sitting there looking at your legal pad, you're not interacting as a human being. So he sees me grinning, I'm relaxing. It's obviously going better than anything else I've done. And then he says, okay, now do it holding my hand. Like, this is weird. But it's true that created that connection between us. And I brought that brought that with me into the U.S. Supreme Court when I argued the case. It went extremely well, and ultimately we won. And I remember it's like a 184-page opinion. Justice Stevens reading some of it from the bench about how we won, about how the Guantanamo tribunals were going down, how the Geneva Convention is going to apply to the war on terror, which is going to mean the end of ghost prisons, end of waterboarding, end of so many different things worldwide, not just at Guantanamo. So it's a huge, huge change in the law. And I remember I walked out of the Supreme Court steps, and there's like 500 cameras from all over the world on me from the media. What's the decision mean was the first question. We hadn't read the decision. We hadn't been given a copy of it. We heard some of it. But I'd written down some words in case we won, and I want to share them with you because I do think it illustrates what the role of the court is in our democracy. I said, well, here's what happened on this day. You had this guy, the lowest of the low, a guy who's accused of being one of the world's most awful men or conspiring with one of the world's most awful men, if not the world's most awful man, Osama bin Laden. And this driver, he brings his case not just against anyone, but the world's most powerful man, the President of the United States. And he brings it not just in some rinky-dink traffic court, but in the highest court of the land, the Supreme Court of the United States, and he wins. That's something remarkable about this country. I mean, in many other countries, this driver would have been shot for bringing his case. And more to the point for me, his lawyer would have been shot. But that is what makes America so special, why I do believe it's an exceptional country. And it reminded me of what then Judge, now Chief Justice John Roberts said at his confirmation hearings. He said, the great thing about the Supreme Court is on the one side of the courtroom, you can have the little guy, and the little guy may not have the fancy lawyers and the fancy arguments, and on the other side can be the big corporation with their law books piled high and their fancy lawyers. But if the little guy's got a good argument, he can win. Not always, but sometimes. That's what makes the court so special. And that, to me, is the court at its best. Now, I've been involved in many cases in which I think the court hasn't quite lived up to that promise, and the one I want to talk about before taking your questions is the one that was mentioned in the introduction, President Trump's Muslim ban. You might remember the scenes at the airports right on that first weekend of President Trump's term when he issued an order that basically barred people from 7 countries that were overwhelmingly Muslim from coming into the United States. And so a bunch of different individuals challenged it as a violation of our First Amendment, a violation of the Immigration and Naturalization Act, and it was immediately struck down within 2 days of it trying to go into effect. And President Trump attacked that judge, saying he was a so-called judge and this and that. And by that point, President Trump said he was going to issue a new and revised travel ban. And I'd been working with Hawaii, the state of Hawaii, for many years on Supreme Court matters. And so I worked with the Attorney General to craft a new challenge for President Trump's second travel ban. And we had it ready to go the minute President Trump issued it. And Travel Ban 2 was basically like Travel Ban 1. It was the same, 6 of the 7 same countries, but which were between 90% Muslim and 99.9% Muslim, except it also added the country of Chad, which I think President Trump thought was some guy. We had it ready to go, and what we argued was this is a religious discrimination. President Trump had campaigned on exactly that. And in his campaign, he had said, I, Donald J. Trump, am calling for a complete and total shutdown of all Muslim immigration to the United States. That's a direct quote of what he said. He later said, quote, I think Islam hates us, and things like that. And so we argued that this was religious discrimination, and we got it struck down in the trial court and then in the U.S. Court of Appeals. And then the president freaked out again, saying so-called judges and this and that, and vowed to bring it to the United States Supreme Court, and we said bring it on. We were very confident that we could win. This time, the president flinched right before I was to argue the case in the United States Supreme Court against his Solicitor General. He pulled back Travel Ban 2, and then he had Travel Ban number 3. And so he told the Supreme Court, scuttle this case. So we did. He scuttled it. Then we had to go back to the trial court and challenge Travel Ban 3. Now, Travel Ban 3 was different than Travel Ban 2 because it added 2 new countries. It added North Korea, because you all know of the overwhelming immigration problem we have with North Korea. And it added about 100 people from Venezuela, from I think the travel office, that now are restricted from coming in. But that allowed President Trump's Solicitor General to tell the United States Supreme Court, well, it doesn't say the word Muslim in it, so it's not discriminating facially against Muslims in the president's order, and it includes some non-Muslim countries like North Korea. Now, I thought we had the killer answer to this, and Justice Kagan understood it right away at oral argument, which was, I said, you know, imagine if on Monday the president says, I hate Jews, on Tuesday bans immigration from Israel, on Wednesday, I don't think he can just stand up and say, well, it doesn't say Jews in it, it only says Israel, therefore it isn't religious discrimination. Nonetheless, the Supreme Court, 5-4, in an opinion by Chief Justice Roberts, said he would defer to the president's national security determination that they needed this kind of discrimination, that was necessary for our national security, which, by the way, I'm not aware of a single serious national security professional who has ever endorsed that view. And even just this week, there was a book by Jeffrey Berman, who was the United States Attorney in the Southern District, that came out that said Giuliani was behind a lot of this Muslim ban stuff and was basically, you know, making all sorts of horribly racist comments about them to Trump that led to the Muslim ban. So anyway, that's a 5-4 decision, which is in many ways the opposite of the Guantanamo decision I was telling you about. And honestly, after getting that decision, I was so discouraged. I didn't want to walk in to the Supreme Court. You know, it was hard to carry on this part of my profession. And one story, and I'm going to leave you with this and then take your questions, but one episode happened to me that really did help me kind of crystallize why I think I want to keep fighting, why I think we all need to keep fighting, why we all need to keep hope and fidelity and faith to our Constitution alive. And it's basically this. So during the arguments in the Muslim ban, it was an incredible security threat to me. I had to have bodyguards outside of my house. There was always a car stationed out there. I had fairly young children at home. And obviously, that's a pretty freaky situation for them. And at one point, my youngest son, Harlan, he asked me, you know, Daddy, what is this case about? Why are you doing this? So I told him about the Immigration and Naturalization Act, which didn't go over too well. And I told him a bit about the First Amendment and religious freedom. That, I think, you know, sunk in a little more. But a little bit later, something happened that crystallized this all for me. So I have a Google News alert on my name just to see all the things people are saying, which are normally not that good. And one day, it hits, 200 hits come up, but it's all the same syndicated column from a woman named Ann Coulter. And Ann Coulter's column, which 200 different newspapers agreed to run, begins this way. Hey, you know what might make more sense than banning laptops? How about banning Muslims? Bear with me here, but I'm certain federal judges in Hawaii can't block a president's ban on Muslim immigration just because they're testy with Trump. To preserve the judicial coup, this Monday, the Ninth Circuit sent out the geriatric word to hear an appeal of the Hawaii judge's absurd ruling. Arguing against Trump's exercise of his constitutional and statutory powers was first-generation American Neal Katyal. There are plenty of 10th-generation America haters. You couldn't get one of them to argue that we should end our country through mass immigration. End our country through mass immigration. And then it really clicked. Why are we doing these cases? Why do we fight this way? Well, partially the idea that being a first-generation American would disqualify me when the country had given me so much. partially the idea that mass immigration would end this country instead of recognizing that's the rock on which the country was built. When I read Coulter's column, I thought about so many things in my past. I thought about my dad, who landed in America with literally $8. And he bought a car for $5 of those dollars, a used car, and slept in it for 3 months. He fixed it up, sold it, and then bought the next car, did the same thing. I thought about his first job offer, which was at a slaughterhouse, which is not a great job for a Hindu. I thought about my mom when my parents were married and she was trying to get a mortgage, and she had listed, she was a doctor, and she had listed her profession on there, and the mortgage officer said to her, "Why did you list your profession?" She said, "Because I'm a doctor." And he said, "But you won't be for a while," pointing at her stomach because she was pregnant with me. And my mom, without missing a beat, just said, "No, I'm just fat." I thought about all the hate mail I got during the Guantanamo case for being a Muhammad lover and things like that, which again is kind of odd for a Hindu to get, but nonetheless, getting Muslims and Hindus straight isn't exactly the business of the haters out there. But then I thought about our glorious Constitution, the First Amendment. Congress shall make no law establishing religion. I thought about the guiding provision or guiding motto of our Constitution, e pluribus unum, out of many come one. That's the answer I wish I'd given my son Harlan, but it is the answer I give to you as we celebrate Constitution Day this year. Thank you.
Thank you, Neal, for those insightful remarks. So now we have some time to open it up to the audience for questions and answers and discussion with Mr. Katyal. We have 2 students on either side of the auditorium. Where are they at? With microphones. And so if you have a question or a comment that you'd like to make, please raise your hand and they will bring you a microphone. It's important that you speak in the microphone because we want to hear what you have to say, but also we are video recording, and so we need to capture the audio as well. So please stand and we'll bring a microphone to you. Please be mindful and respectful of our speaker, but also our community, and keep your comments on topic and respectful. So with that, we'll open it up to your questions and answers.
Okay, so earlier you referenced how there can be disagreements between the justices and some write some very passionate dissents. So, and then there's also they don't take it personally joke. So I'm just wondering, how do you go about not taking this all personally, actually?
I love that question, and thank you, because I think it really does illustrate the spirit of Constitution Day. Because if you think about what is our Constitution but a document for people who we knew, our founders knew, were going to disagree with one another. And one of the things I do love about the Supreme Court at its best is that it's not personal disagreement, that you can trust people's motivations and they can come at it from different things, but at the end of the day, they have a common calling. And we as advocates have a common calling. And I feel like we've lost a lot of that. In part, I do think, I'm not actually a particularly political person. Like, there are many Republicans who I could easily vote for. But I do think that President Trump coarsened the dialogue and made it so that if you disagreed, that you were, in some way an evil person or a socialist or a leftist or, a child pedophile or all the other things that he opened the door to. And it's something that really worries me because it's a decline of civics in this country that is happening. And it's, like many things, when one side does it, then the other side does it too. And so now everyone's a bit to blame for this coarsening of our dialogue and fewer shared spaces where we can all get together and actually have a reasonable disagreement. And so if I have a wish for American democracy, it's that it does look more like the Supreme Court of most of my lifetime. I want to take the last year or two out because I think the last year or two, unfortunately, the Supreme Court itself is starting to have some of those trends from popular society start to infect it. I'm not aware of earlier times when I've been practicing there in which the justices were publicly, giving speeches that were essentially attacking one another. I'm very worried about that. I had the privilege of clerking for Justice Breyer, and I was at that point probably much more of a knee-jerk liberal, and Justice Scalia would attack him in some opinions and would say things that are really mean in the written word. And we'd all come in as his law clerks and say, Justice, you got to respond, you got to respond. He said, no, I take it he has a good faith disagreement with me. I'm just going to, lay out my argument, never use a bad word about him or anything like that, and respectfully disagree. And that is all I saw from Justice Breyer in his more than 20 years of service on the Supreme Court. And I think about it a lot because, I also feel these tendencies, particularly when I see people defending what I think is indefensible, some of Donald Trump's behavior. But I try and be guided by Justice Breyer's views on this. And it's not just Justice Breyer, but he's the one I know the best and just saw it personally every day. Respectful disagreement. So that is truly, what I think Madison is getting at in Federalist 10 and 51 ultimately, about this far-flung country which is going to have disagreements, and it's our job to carry that flame of respectful conversation forward.
Hi. So this summer I had the fortunate privilege of interning at the State Department in DC, and through my office and the various other interns and people I got to meet, I learned a lot about different goals and ways that Americans can promote public diplomacy and American values. And I was just wondering what your take of, what do you think is one of the main foreign policy issues that we should be striving towards through promoting American values in this current climate that we're in internationally?
Yeah, well, I do think it's hard to promote. This isn't really my field, but I'll just offer a couple of thoughts because I do a fair amount of international speaking, and I do think that January 6th and some of Trump's coarsening of behavior has undermined what we stand for in the world. And, at its best, we are a country that is e pluribus unum, that we do disagree with one another, but we're stronger together than we are divided, to use, a spin on President Lincoln's phrase. And, so we have to solve our problems at home first a little bit before we can start trying to export them abroad. So I think there's a lot of democracy protection, voting protection stuff that's got to happen here. I have this case that at the Supreme Court that I'm lead counsel in called Moore versus Harper, which will be around a December or January argument. And that is one of the most important cases I think the Supreme Court has ever heard. And because I'm the advocate, I'm just going to lay it out and not try and spin it or anything, but just tell you what the case is. So you might remember that in the 2020 election, there were 62 different courts that ruled against Donald Trump in all these different election disputes. Many of those rulings came from state courts, state Supreme Courts, including ones with conservative-led ones, but just thought there were no substance to his allegations. Well, as a result, the Republican Party has adopted this new theory that says under our Constitution, state courts have no business in federal elections. They have no role to play whatsoever. It is 100%, they say, up to the state legislatures to do whatever they want. And the theory is going to benefit Republicans because state legislatures, the Republican Party has been incredibly savvy at going after and trying to control state legislatures for any number of years. And so if they win, this is going to really, really change how voting takes place in this country, and will, potentially lead to massive disenfranchisement. 3 justices have already signaled support for this Republican theory, so we'll see what happens. I'm optimistic because, this court claims to be originalists, which means that they follow the original intent of the Constitution, like what Madison and Hamilton thought. And the originalist evidence in support of this theory is less than what you can find on the bottom of my shoe. And there's a lot of support against it. But we will see. It'll be a vigorous, interesting argument at the court.
Hello. I was wondering what your thoughts were on the Oklahoma tribal case that was ruled a while ago, and what the aftermath will finally be.
Yeah, so this is a case, basically, the Supreme Court for many years has been pretty hostile to Native American rights. But, with the elevation of Justice Gorsuch onto the court, that changed a bit. And they became more solicitous of tribal rights. And this case from Oklahoma called McGirt was part of that, and basically allowed for, it basically said that it made it harder to prosecute Native Americans and non-Native Americans on tribal lands and the like. Some justices thought that was too broad of a ruling, and it was cut back a bit this year in a follow-on case, but not cut back, hugely. At least I haven't had time to actually focus in on the details of the new case, but I know it was cut back somewhat. I think just zooming out of that case more generally, it's a really interesting question where tribal rights are going to go in this new court with Justice Barrett on the court. Actually, Justice Ginsburg, I'd argued several cases on behalf of tribes in front of her. She was not great on tribal issues. I don't think Justice Barrett's had much of an occasion to decide this, but this is a little example, and I don't mean to overclaim it, but it's an example of where sometimes political parties don't predict the way Supreme Court justices are going to vote. Justice Gorsuch is far better, from my perspective as someone who defends tribes, far better than many other justices appointed by Democratic presidents. And there are other examples like that, just quirky things. Justice Thomas, who's generally very pro-business, but who doesn't believe in this thing called the Dormant Commerce Clause, which conservatives have been using for years to strike down government regulation. So some oddities, but I don't want to overclaim that because, when you look at a term like last term, which was the first term in which Justice Barrett had replaced Justice Ginsburg, you see dramatic differences in how the U.S. Supreme Court is approaching cases. Roe versus Wade being overruled after it had been the law for 50 years, after 3 Republican justices in 1992 came together, Souter, O'Connor, and Kennedy. They came together and said, look, there are criticisms of Roe versus Wade. Maybe it's wrongly decided, but it is integrally woven into the fabric of our land. Our social expectations have crystallized around it. They said it would be a disaster for the court's legitimacy if they overruled it, because it would look like it's just the individual preferences of justices, not law being done. Roe versus Wade was the hardest case for the Supreme Court to overturn. It was the one that the Republican justices had staked the court's legitimacy on, saying you couldn't overturn it, and they started this year there. And then they went and did a similar thing with gun control and a similar thing with climate regulation. So this is a different court. And I do worry that it is out of step with where America is.
I think we have time for one more quick question.
Oh, I'm not sure that I can be that quick, but I do want to start with maybe an appropriate quick thank you. First of all, to you, Tony, to Kathy Grimes, to the Center for Democracy for having such an outstanding speaker. So thank you so much. What a treat. Also, in between us, we have like truly great Americans. I saw at least 4 judges come into the room, and Admiral. And just a few weeks ago, I went to the retirement ceremony of an admiral in the Coast Guard who'd been serving for the Coast Guard for over 40 years. And I would just say, you, sir, are no less a great American, so thank you. The question I have, by the way, you are one of the few gentlemen that I welcome into my bedroom every evening, so I feel like we're already somewhat intimate. But I am worried from listening to you night after night and hearing what's going on with the Mar-a-Lago case as it advances seemingly to the 11th Circuit, and then it's going to go, in all likelihood, win, lose, or whatever, it's going to move on up. And what you were just talking about, whether it's the overturning of Roe or what have you, that will there be an honest look at the law, and what your opinion is on that? So thank you.
Thank you for the kind words. I think that if the Trump case goes to the Supreme Court on this special master thing, it's not going to be hard for the Supreme Court to say, no, federal judge, you can't stop the government from using 100 classified documents as part of their criminal investigation and as part of their national security review. It's just a wildly, wildly implausible argument. Honestly, that Florida judge's opinion, I have not had, I think I've probably taught 2,000 law students at Georgetown. Any one of them would have written a better opinion than that thing. I mean, really, it's that bad. It's atrocious, and it's not going to hold up. So I know that there's skepticism about the Supreme Court among some quarters and whether they'll do the right thing. I'd urge you to think about the fact in the 2020 election, the Supreme Court rejected Trump time and time and time again. I'd urge you to think about that in a case I was involved in on executive privilege this past year when the president asserted executive privilege, or former president, earlier this year against the congressional January 6th investigation. The Supreme Court rejected that 8-1 with just Justice Thomas dissenting. So, I do think that Trump would lose at the Supreme Court. And more generally, and I'll just leave you with this thought, because I think he did operate with a lot of impunity for many years and dangled pardons and things like that against potential witnesses against him. But he's not the president now, and he's been caught red-handed with the goods. And these are really serious goods. My job before being in the Solicitor General's office, my other job at the Justice Department was being National Security Advisor at the Justice Department. And I can tell you that those documents that he had there, that picture, is the most serious stuff we have. It's literally spies in the field and things like nuclear information. I remember when I'd go in and read some of that stuff, I'd be terrified I'd take a pencil out by mistake of the room. It doesn't matter what your party is, you just never, ever do anything like that. And to just make it really concrete for you, because people say, oh, there's a national security harm and so on. What does that mean? Well, here's what it means in practice. We have spies all over the world. Some of them work in foreign governments. Some of them risk their lives to give us information. If you're one of those spies and you read about Trump having this stuff and other people potentially having access to it, you have no idea if it's about you. You just know there's 100 of those documents at least, if not more, 1,300 pages, I think, or something like that. You don't know if you're one of those documents and who's read it. So are you going to really be going and giving more intel to the United States in that period until you get certainty about what that stuff is? Of course not. We need to reassure those people that they're okay, or if they're not okay, we need to save their lives and pull them out right now. And what this federal judge in Florida did is say, oh, nope, you don't have to do that. I think Donald Trump's, the harm to his reputation outweighs that. That's just, I mean, that's not law. That's not going to stand up. So, you know, I'm very optimistic that justice will be done. And I think it's an enormously hard thing. I don't think that Merrick Garland relishes the idea of being the first attorney general in the history of the United States to prosecute a former president. But I don't think Donald Trump left him any choice. So he kept refusing to turn over the documents time and again. And it wasn't like, again, he took like modest documents about, whatever, but he took serious stuff. And I can just tell you, I know 100% for sure, if I took even one of those documents, I wouldn't be here. I'd be behind jail, be behind bars. So with that, thank you all so much. I wish you a great weekend. Thanks for coming out on a Friday.
Thank you all for joining us this evening. Thank you all for joining us this evening. Before I just want a couple of announcements. We have several really impactful programs coming up from the center and from the college. One of them on Tuesday, October 4th, the center is kicking off its inaugural Gwen Ifill Lecture Series with award-winning journalist Maria Hinojosa. And then on Friday, October 7th, the college is hosting a national media panel moderated by Jessica Yellen, featuring Bill Kristol, Mara Eliason, Jelani Cobb, and this will be all for the public as well. Both of these programs will be hosted in the new Performing Arts Center, which will be unveiled later this month. So I invite you all to join. You can find more information at the college's website. And thank you, Mr. Katyal. We really appreciate your time.